first of all, if we had a closing that happened recently where there were multiple parcels that were all part of a conservation easement. And for those who don't know what that means the government had given some tax incentives or some tax savings so that they would not develop the property. They would leave it for agricultural use or whatever use it was. And let's just say there were 5 parcels. I'm making this piece up. 4 of the 5, they found the parcel, they found the tax bill, they prorated it correctly at closing, but the 5th parcel was not found. And so it wasn't a big deal. It was less than $1,000, I believe around $800. But what happened is after the fact, the home buyer, the buyer of the property, found out that they owed some additional taxes. And the taxing authority, I believe in this particular case, it's a county, is saying you owe us the taxes and you need to pay it. How does that work? Because there was title insurance purchased on that property. So how would this situation be handled?
Yeah, ultimately, if they couldn't handle it the way I'm about to tell you it's normally handled,
okay,
the title insurance would step in because that would have been an issue, but then they would go back to the parties that I'm going to tell you about to handle.
Okay.
And so that's really what should happen. But in that conservation use easement for 10 years, you get to pay less taxes as long as you're not building structures or anything, except there can be a house.
Right.
In your example, the homeowner or the buyer of the parcel and the seller of the parcel that wasn't collected the taxes.
Correct.
So let's just call it a small amount, 1,000, and let's say it's exactly half the year, 50-50. In the closing, generally, in our closings, we have the buyer and seller sign a document, the 3rd page of the settlement statement, or our master settlement statement, and there's another document. They're basically duties to cooperate. They agree to cooperate. If taxes were missed or need to be reprorated, they would do that.
Yep.
And so in that instance, we would call them and say, this parcel was missed, and that would happen. And they would pay to us, which we'd pay the tax bill. If neither party was agreeable, the buyer shouldn't be agreeable to the half they shouldn't, so they should make the claim.
Right.
The half that they owed, they owe it, okay?
Right.
And so the half that they don't owe, they could make a claim, and the title insurance company would cover it, and then they would go after the seller because the seller had agreed to pay it, and they owed it. It's like a payoff. If you miss a payoff and you sent $200,000, it's $230,000.
Yep.
Seller goes, well, it's your fault. And I'm like, well, if I'd sent $280,000 and got the money back, it's also my fault, but you lose. So it's not a good rational argument to say it's your mistake.
Yeah.
Mistakes are made, but they still owed it.
Joe, when somebody says in the state of Georgia that we've closed in escrow, they don't mean that we've closed escrow like they mean in lots of other states. So talk to me about the difference in those two things.
On the western side of the world, I guess on the other side of the Mississippi, you have escrow states, which means there's a buyer signs one place, a seller signs another. The lender documents come in, the recording, they send it to the courthouse, and then they finally disperse.
Yep.
So let's just say those are 5 things, and it's a checklist, and it can happen over multiple days.
Okay.
And so in the East Coast, it's a wet closing, which means we all crash at the table. We wet sign, we all sit there, then we fund it. Basically, we get approval from the lender, and everything happens like chaos. It's not chaos, it's controlled chaos.
It's organized chaos.
So then, organized. And so we fund it, and that's called a wet closing as opposed to an escrow or dry closing. Well, on the East Coast side, if you don't fund it, something happens, the money got wired late. It could be anything, not particularly anybody's fault or somebody's fault.
Right.
But what do? You want to come back and redo it all tomorrow or the next week? Generally, they'll say, let's suspend everything. And they call that an escrow closing.
So buyer, seller sitting at the closing table, they finally realize that the lender is not going to be able to get everything funded by the end of the day today. And so they say, hey, how about closing an escrow and we'll get it funded on Monday? Is that a good example of something that might cause a transaction to close in escrow?
Yeah, it's not always the lender, but the lender does have to approve whatever the reasoning is, because it's the lender's money that's getting tied up, and it's the lender who basically has to control that transaction as far as the rules go,
right?
Instructions.